Lawyers/solicitors, what is the strangest or oddest law that's won a case for you? A guy got drunk and decided to ride his horse through town. This was a small town in North Carolina. Well, he would stop at each intersection and fire his pistol in the air like some Wild West cowboy. Anyway, the guy was charged with a DUI and discharging a firearm within city limits, which was a felony. So as one would soon find, it is not just mandatory but a law that you must fire your firearm into the air at an intersection when coming through town on your horse. An old blue law that never got erased. He still got the DUI and his horse got impounded, but the dumbfounded judge dropped the other charges. The weirdest case I have ever dealt with was *Jolie v. Pauletti 1999 OJ. Number 1728, S.C.J. I did some research for this case when I was a law student. Some background: this was at a time when the Ontario Court of Appeal had held that, if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That is not the case today. It was discovered that this position basically ruins summary judgment as a useful process, but it was at the time. In such a motion, all facts alleged by the plaintiff would be assumed to be true. What happened was this: a man sued, among others, the College of Dental Surgeons, for persecuting him and interfering in his ability to live as a generic Martian. The plaintiff claimed he had been cloned from space debris NASA found in the 1960s. He claimed he had a genetic test to prove this, but it had been falsified by the CIA as part of the conspiracy against him. Well, naturally, this claim raises the concern that the plaintiff was bonkers, but there was no evidence, aside from his bizarre claims, of that. In court, the case was decided on two alternate grounds: first, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on the more entertaining basis of standing. Justice Epstein held that only a person could commence an action in Ontario. The rules of civil procedure define a person to be either a human being, or a corporation. The plaintiff's whole case was based on him being a Martian. If he was not a Martian, his case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. In NW, Arkansas, prosecutor filed involuntary commitment against a local man who had come to believe he was Jesus Christ. Judge ruled against the commitment. Prosecutor asks how he could rule against committing someone clearly insane. Judge replied, "The law requires you to prove he's a danger to himself or others and you didn't meet your burden. Besides, this Friday is Good Friday and he's got a busy weekend coming up." I had a case where a guy was charged for running a red light. The thing is, he had been sitting at the lights for 5 minutes and it hadn't changed. The wording of the specific section under which he was charged related to stop signs and traffic lights and referred to them as traffic regulation devices. I successfully argued that as the traffic light wasn't changing, it wasn't regulating traffic, and he got off. I couldn't believe it when the judge ruled in my favor, neither could the police prosecutor. 47 U.S.C. 227, b. Restrictions on use of automated telephone equipment. Law student working at law firm. We have a fax machine that gets tons of spam faxes. Our chief partner has a vendetta against spam, and he uses it to give us practice in researching and writing petitions. So we catalog each fax, send replies to take us off the list, document everything and wait for them to fax us again. Then we follow up with the FCC complaint and demand letter. A couple times this has ended up with the person getting mad and sending us retaliatory faxes, black sheets of paper. If they stop sending, we don't do anything, but we've gone to small claims a couple times, and gotten $500 per page a couple times. We also got someone trying to sell drugs through fax, but we just turned that over to the police. There was a case here in Hawaii that got thrown out like this. Someone got pulled over because the police saw she had way too many passengers in the car. Then they noticed she was drunk. Open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle, so the issue was that all the extra passengers weren't wearing seat belts. Well, this failed also, because the law only says that every available seat belt needs to be in use. If you have 6 passengers and only 5 seat belts, there's nothing at all illegal about the 6th being unrestrained. So, since there was no probable cause to pull her over in the first place, even though she was indefensibly drunk, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they can just party back there, while anyone in the cab unbuckled would get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs. I had a roommate who got picked up for public intoxication one St. Patrick's Day. He was in jail for a couple days, which seemed odd for a pie. Turned out he had a warrant from another city for escaping jail. The year before, he got picked up for public intoxication, on St. Patrick's Day. He had a hazy memory of being shuffled down a hallway with a bunch of other drunkards at the jail before walking through a door and suddenly being alone outside. From there he just walked home. The police never came looking for him, so he wasn't even sure it happened. Anyhow, it turns out they never even properly booked him, so while there was a warrant for him escaping jail, there was no record of him ever being arrested. Case dismissed. A buddy's mom got pulled over for expired tags, and when the cop got to the car, she wasn't wearing her seat belt. To top it all off, her license was expired. Trying to be nice, the cop dropped one of the violations, and wrote her up for the other 2. She came home angry that she'd gotten a ticket, and showed all of us hanging out. I looked at it, and asked a simple question. Why did he pull you over? At the time the ticket was written, cops weren't allowed to pull you over for not wearing a seat belt, which was one of the violations on the ticket. Without a valid reason to pull her over, how would he have known about her expired license, which was the other violation on the ticket? He let her off for the only violation he could have pulled her over for. She went to court, and asked the same question. 10 minutes later, she walked out of court without having to pay a single penny. I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property, the theory being even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very, very stupid law that they would be exempted from the rule that they can't be sued for sidewalk injuries unless you can show they were on notice of hazard. Meaning, you would have to show that you informed the Secretary of State/Governor/Mayor etc. of the exact specific crack in the sidewalk before the injury occurs, and you had to do so in writing with ample time for the city to remedy it, 180 days in advance IIRC. Under normal circumstances, this is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a non-profit called Big Apple Maps which would go around the city and with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps while serving copies on the government, with the express purpose of combating sovereign immunity defenses in slip and fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map. I have one where we won, but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40 to 60 hours a week preparing slop for the hogs from expired restaurant food, and cleaning the hog barns. He reeked every time I met with him, even after showering. He said it was miserable. Well, he found out that some Muslim inmates, who couldn't work with pigs, were offered to be able to work at the police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction, but then the prison changed their policies in response. Inmates who couldn't work around pigs, or didn't want to, would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. Over 10 years ago, I had been at fault for rear-ending someone else. I had no insurance and my license had expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of a fix-it ticket about my suspended license. I sorted that out in the days after and nothing came of that ticket. The cop had mentioned that he had to write the insurance ticket, but to take it into court and get it lowered. I was desperate to try and get my $800 insurance ticket lowered because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me and said, "I would like to use Mr. South Seattle's case as an example to the gallery." I almost died. He went on, "This is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. South Seattle accountable to this." My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure that cop deliberately didn't write the date on that ticket. Thanks, officer. Something similar to me. About a month before Christmas, someone merged into me. Caused me to hit a curb, spin out and then hit someone else. No insurance. Thought I was going to jail for sure. I didn't argue with the cops, I was just super apologetic and said I was stupid for driving without insurance cause I was saving to make sure I had Christmas money for the kids. Well, I got the ticket for no insurance, and some other ticket. Asked if I was going to jail or getting my car taken. He kinda chuckled and said, "Well, if you want." I was confused. Waited for it to all be done and went home. Went and handled the ticket and got my license suspended for a year. I was supposed to have a court hearing for it, but when I showed up to court they said there was no paperwork. So then I went down to the police department that issued the citation, like an idiot, and requested them to find the info so I wouldn't be fucked on a didn't show to court thing. They said they'd call me back when they got it situated. I still haven't received a call or anything in the mail from the courts. I've had my license back for 2 to 3 years now. I'm convinced the officer purposely didn't file it so I didn't get even more fucked. Learned my lesson though. Insurance all the time now. Very expensive insurance. LOL. We bought a car from a friend for $1, so we didn't owe taxes on it. The car was in bad shape, so she rode down in a following vehicle to make sure my wife made it home. The last 2 miles of a 200-mile journey, My wife was stopped at a stoplight by a cop who noticed expired tags. She ran the plates, and found the plates went to another car, which belonged to a third friend who loaned us a junker for a small while. So my wife got a ticket for expired tags, no emission sticker, license plate of a different car. My wife showed up in court to pay massive fines. But when she pleaded her case, explaining they had to get the car down to our place somehow, and no one would tow it for 200 miles without a flatbed, and we were super poor and needed a car, and we would not be able to pay the fines, the judge asked the cop if she'd prosecute, and she said, no. And the case was dismissed. I one day got a letter from the court saying I had a warrant for failure to appear. I knew about the case, but hadn't received a court date yet, so this was confusing. I called the courthouse and the lady said that one morning every week people with warrants can come in and deal with their warrants with a judge. Okay. So I go to court and sit there as person after person goes up, explains that they never got their new court date, and the judge throws them in jail. I've never been to jail, so I'm getting more and more scared. They are taking people in alphabetical order, and my name is near the end. Finally it is my turn. I step up to the front of the room and the conversation goes something like this. Judge, why did you miss your court date? Me, my case was coming from a different courthouse and I never got the date after the case was moved here. Judge, looks like your letter was returned to us. You are the only person who hasn't lied to me today. Your new court date is X, you are free to go. I can't even begin to explain the relief. Had a case where my defendant/opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond, executed by the individual defendant, or a corporate officer. When my opponent's assistant electronically filed the appeal, she attached a .pdf of the bond without the corporate signature. There's no question in my mind they had the bond with the requisite signature, and simply attached the wrong version of the document to the filing. Wish I could say there was a huge court fight over this, and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button, and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client. But I doubt it. Showing similar happened to me. I was, to my shame, too drunk to drive and swerved pretty badly on the highway. I noticed the police officer following me, tried to switch lanes and get off the exit. It didn't work. He kept following me and pulled me over at the next light where I wanted to make a left turn. He asked me what the swerving was about. I said I'm just tired, which was true. I was working a lot back then. It's a busy light off the exit. He asks me to drive to the gas station after the left turn. He asks for my license. I didn't have it. I give him my registration and my social. He goes to his car and talks to the other cop that shows up. He comes back to the car to tell me it's my lucky day and to head on home. I can only assume a lawyer would have had a field day with an officer letting someone he suspects to be drunk drive to move his car. Rather than get berated for it, he let me go. I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside drawer, walked into his living room and confronted a figure in the dark. The person didn't identify himself but moved towards my client, who fired a single shot that went through the person's shoulder. Turned out it was my client's stepson who had snuck out, been drinking underage, and stumbled home. The problem with the situation was that my client was a convicted felon. Several times over. That meant that while the shooting itself was legally defensible, his possession of the firearm was not. We looked into the history of the gun itself, as our client had indicated it had belonged to his grandfather, who had served in the U.S. Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the very first batch of firearms distributed from Colt to the U.S. Army at the Augusta Armory. Florida Statute 790.001 creates an exemption of firearm-related laws, including the prohibition for felons to possess a firearm, if the firearm in question was an antique, meaning it was manufactured prior to 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potential mandatory prison sentence.